Good morning, students. Today we are discussing about some laws regulating business competition. These are some international laws regulating the business competition. Firstly, Sherman Antitrust Act 1890, one of the oldest law regulating the business competition, that is Sherman Antitrust Act 1890. The Sherman Antitrust Act of 1890 is a United States antitrust law that regulates competition among enterprises that was passed by Congress under the presidency of Benjamin Harrison. And this act is named for the Senator John Sherman, its principal author. The act was written by Senator John Sherman, and it is named on his name. The Sherman Act broadly prohibits the anti-competitive agreements and unilateral conduct that monopolizes or attempt to monopolize the relevant market. That is, the law attempt to prevent the artificial raising of prices by restriction of trade or supply. So, in order to prevent the artificial raising of prices by restriction of trade or supply, to prevent such malpractices, the law tries an attempt. Then, innocent monopoly or monopoly achieved solely by merit is legal, but acts by a monopolist to artificially preserve the status or nefarious dealings to create a monopoly are not. So, the competitors do not try to create a monopoly. It is illegal. But a monopoly achieved solely by merit is legal. That was the other feature of this act. And the purpose of the Sherman Act is not to protect competitors from harm from legitimately successful businesses, nor to prevent business from gaining honest profit from consumers, but rather to preserve a competitive marketplace to protect consumers from abuses. The main purpose of Sherman Act was to protect consumers from the abuses of the competitors. That was the basic purpose. Sherman Antitrust Act of 1890. And next is Federal Trade Commission Act 1914. The Federal Trade Commission Act of 1914 established the Federal Trade Commission as a body of specialists with broad powers to investigate and to issue, seize and desist orders to enforce Section 5, which declares that unfair methods of competition in commerce are unlawful. Here, Section 5 is very important, which declares that unfair methods of competition in commerce are unlawful, and as per this act, it established that commission, Federal Trade Commission, which is a body of specialists, and they have the right to enforce Section 5. And this act was signed into law by Woodrow Wilson in 1914, and it outlaws unfair methods of competition and unfair acts or practices that affect commerce. That is the peculiarity of this act, Federal Trade Commission Act 1914, to outlaw the unfair methods of competition and unfair acts or practices that affects sales, commerce. Next is Clayton Act 1914. The Clayton Antitrust Act of 1914 was a part of United States antitrust law with the goal of adding further substance to the U.S. antitrust law regime. The Clayton Act sought to prevent anti-competitive practices. There is a law already formed in 1890, that is Sherman Act, and the Clayton Act supplements the Sherman Act by prohibiting certain specific practices such as price discrimination, tying clauses, and exclusive dealings. So, this Clayton Act is an amendment of Sherman Antitrust Act, and like Sherman Act, much of the substances of this Clayton Act has been developed and animated by the U.S. Supreme Court. And next is Robinson-Patman Act 1936. The Robinson-Patman Act is a federal law passed in 1936 to outlaw price discrimination. So, the basic purpose of this act is to outlaw price discrimination. The Robinson-Patman Act is an amendment to the Clayton Act of 1914. Okay, Clayton Act was an amendment of Sherman Antitrust Act, and this Robinson-Patman Act is an amendment of Clayton Antitrust Act of 1914, and is supposed to prevent unfair competition. Basically, all the purpose of these entire acts was to prevent unfair competition. The law prevents distributors from charging different prices to various retailers. So, the act only applies to interstate trade and contains a specific exemption for cooperative association. It is applicable only to interstate trade, and there is an exemption for cooperative association. So, this is Robinson-Patman Act in 1936, which is an amendment of Clayton Act of 1914. Next is Wheelerly Act 1938. The Wheelerly Act of 1938 is a United States federal law that amended Section 5 of the Federal Trade Commission Act to prescribe unfair or deceptive acts or practices as well as unfair methods of competition. So, this is an amendment. This law is to amend the Section 5 of the Federal Trade Commission Act. And the Federal Trade Commission is formed to enforce Section 5, and to amend the Section 5, a Wheelerly Act was passed in 1938. And this act is to prescribe unfair or deceptive acts or practices as well as unfair methods of competition. And it provided civil penalties for violation of Section 5 orders. So, this tries to enforce or enact Section 5 more strictly. Wheelerly Act of 1938. Next is Lanham Trademark Act 1946. The Lanham Trademark Act, enacted July 5, 1946, is the primary federal trademark statute of law in the United States. And the Act prohibits a number of activities including trademark infringement, trademark dilution, and false advertising. This is basically to control the trademark activities, that is trademark infringement, trademark dilution, and false advertising. That is, the Lanham Trademark Act regulates brands and trademarks. So, these are some important international laws regulating the business competition.